Hello, hi, and welcome. The third unit of the first chapter in Module 2 deals with the contract of agency. So, in the overview of this particular unit, that you are going to know about the meaning of agency and the appointment as well authority of an agency and the subagents. What are the way of appointment of sub-agents, and what are the duties and rights with respect to the sub-agents to the agent and principal will be discussed here. And next one is ratification of actions of an agent by the principal, how it will be carried out, and what are the certain essentials of a ratification of certain actions will be discussed here, and revocation of authority, which is leading to the termination of agency, and what are the various modes of termination of agency and all will be discussed under this topic. And the next one is the various duties, obligations, and rights of agent. So, because in the contract of agency, it is the agent who plays a very key role. The obligations and rights of the agent will be studied in depth, and as well about the agent, these topics are very pertinent in your examination point of view. And what are the effect of agency on contract with the third parties, when a third party comes into picture, and how the parties to a contract of agency will get effect with reference to or vis-a-vis the third persons will be discussed under this topic. And these are the very minimal topics that are given here under the agency, and now we will discuss one after the other in your examination point of view with respect to the possible question that may likely to come out of the course content available in your study material. Right. The first possible thing is what is the meaning of agent? The first possible question out of the course material is what is the meaning of agent, and what is the test of agency, whether there exists the agency or not. For that there are two testing conditions. So whether what is the test of agency, and write about appointment of agents, how the agents will be appointed. As you are aware that in a contract of agency there are two parties, basically one is a principal and other one is a agent. So when it comes to the agency, as per the Indian Contract Act 1872, it does not define the word agency. The word agency was not defined as per the Contract Act 1872. However, the word agent, who is a key person in the contract of agency, is defined as a person employed to do an act for another. A person employed to do an act for another to represent another in dealing with third persons. You know that what a agent will do. What the agent will do? Agent is a person. He is being employed by the principal to do one or the other act on behalf of the principal, right? Or to represent another. Here another means the principal, to represent another in dealing with third persons. So in the modern day business, a principal may not be able to deal with the various people. So that is the reason he do have the agents in different locations, and the agents will be given certain guidelines, rules, and the regulations to be followed, and accordingly they deal with the third persons upon the directions from the principal. So they represent the principal in dealing with the third person. So the agent definition is given. The agent definition you have to remember. The person for whom the act is done or who is so represented is called principal, right? So for the person for whom the act is done is the principal. And a test, so the agent and principal, both the terms are defined. However, the term agency was not defined in Contract Act 1872. Now just have a look at the test of agency, whether there exists a agency or not. To say that, you have to conduct a test. So the test is given in the form of A and B. So if you go through these 2 points, you will be able to say the agency whether exists or not. So the point number 1 says that whether the person has the capacity to bind the principal and make him answerable to the third party. So the first test is that to say the agency is existing, the person here, the person means agent. If he has the capacity to bind the principal and make him answerable to the third party So whether the person has the capacity to bind the principal and make answerable to the third party is the first test, because the agent always acts on behalf of a principal, and unless the principal is binded to the third party to the actions of agent, there could not be any agency. So that is the reason the first test should be satisfied. And the second test, which is given in the B, whether he can establish privity of contract between the principal and third parties. So for the actions of the agent, there should be a privity of contract should come into picture. If it is possible, then in all such cases there exists a agency, the test of agency, point A and point B. And if the answer to these questions A and B is yes, then there is a relationship of agency. Agency is a comprehensive word used to describe the relationship between one person and another. Whether first mentioned person brings the second mentioned person into a legal relation with others will tell about the agency, right? And when it comes to the appointment of an agent, who will appoint? Who may employ an agent? Will all the people can employ an agent? No. For employing an agent, a person should have certain qualifications. He should not be of unsound mind and he should not be of a minor. So to appoint a person as an agent, the person should have certain qualification according to section 183. Any person who is of the age of majority, according to the law to which he is a subject, and who is of a sound mind, may employ an agent. So a person who satisfies these two conditions, the first condition of age of majority and the second condition is of having a sound mind, if these two conditions are satisfied by any individual or a person, all such persons can employ an agent. Thus a minor or an unsound mind person cannot appoint an agent. This is about the appointment of a agent and who can appoint an agent. So the next aspect is that who may be an agent, who can be appointed as an agent. As per section 184 provides that as between the principal and third persons, any person may become an agent, but no person who is not of the age of majority or of sound mind can become an agent, so as to be responsible to his principal according to the provisions in that behalf herein contained. So again, to appoint a person as an agent, principal should be of a major and of a sound mind, and at the same time the person who is going to be appointed as an agent under section 184 should also be of a major having the age of majority and of sound mind. Age of majority and sound mind, these two are the essential prerequisites for a person to get appointed as an agent. So the other phase of this agent is also that the section 184 of the Contract Act provides that any person may become an agent, in other words, even a minor. So the other way it says that a minor also can become an agent and the principal can be bound by his acts. So the principal is bound by his acts. If a minor is chosen as a agent for the actions of that particular agent, the principal is liable to the third parties. So this is what the act provided for. Agent is a mere connecting link between the principal and the third party. This point you need to remember. So it is agent is a connecting link between principal and the third party. It is immaterial whether or not the agent is legally competent to contract, isn't it? So whether the agent, it is immaterial whether the particular agent is an competent to a contract or not, because he is not going to have any contract with the third party, and he is going to connect the link between the principal and the third party, and thereby the privity of contract will emerges or arises between the principal and the third party. So right, so that is the reason there is no bar to appoint. There is no bar to appoint a person who is a minor as an agent as per section 184. However, in considering the contract of agency itself, the contractual capacity of the agents become important. So it is important to have a major as an agent, but it is the wish of the principal to appoint sometimes a minor as an agent. However, in all such cases, it is the principal who is bound by the acts of the minor who is appointed as an agent. So thus, if the agent happens to be a person incapable of contracting, then the principal cannot hold agent liable. So principal had a limitation. Whatever the agent do as an agent, if he is a minor, the principal cannot hold the agent liable in case of his misconduct, or where the agent he has been negligent in performance of his duties. In all such cases, the principal cannot hold the agent liable. Right? This is all about the two facets of appointment of an agent by the principal. Right? And consideration is not necessary according to section 185. According to section 185, no consideration is required to create an agency. The acceptance of office of an agent is regarded as a sufficient consideration for appointment. So this is about the consideration which is not necessary in all the case to get a person appointed as an agent. So here the consideration is the acceptance of office of an agent. itself is considered and sufficient consideration for appointment. So this is all about the first topic, and the possible question could be what is the meaning of an agent, what is the test of agency, and you have to write about the appointment of agents. So agent can be appointed by a principal. The principal should always be should attain the age of majority and should be of a sound minded person, and in the same way the agent also required to be attained the sound of sound attain the majority of age, as well as he also should possess the sound mind. If sometimes principal may appoint a minor as a agent, in all such cases it is the principal who is responsible and liable to the third party for the conduct of an agent. He cannot make the a minor agent as a liable to him for his misconduct or negligent performances. This is all about the first topic. And the second topic here is what are the various modes of creation of agency? What are the various modes of creation of agency? How many modes are there to create a contract of agency? So here, in the words of Desai, the Supreme Court of India, the relation of agency arises whenever one person called the agent has the authority to act on behalf of another person called principal and consents to act. The relationship has genesis in the contract, right? The relationship of the principal and the agent may be created in any of the following ways. So these are the various modes of the relationship of the principal and the agent that can be created. So the first one is express appointment and implied appointment of agent, and appointment of an agent by necessity, and appointment of an agent by as a estoppel or by holding out, agency by ratification at a later date, certain actions done by a person. So a relation of a principal and a agent can be get established for certain actions which have been done before having the agency, and later on that actions can be ratified by the principal, so thereby the agency will come into picture by the ratification of actions which have been done earlier. So these are the various modes. There are five modes that we will be going to understand in detail. The authority may be express or implied according to section 186. The authority of an agent may be express or implied. Right. So express authority. An authority is said to be expressed when it is given either by words or spoken or written. In all such cases, we can say the authority is given to some other person to act as an agent by any one of these three modes, which gives a relation as a principal and agent. And say this example, you will understand that A is residing in Delhi and he has a house in Calcutta. So here A is a principal, and A appoints Mr. B by a deed called the power of attorney as a caretaker of his house. So agency is created by a express agreement, because there is a power of attorney. No, power of attorney is in writing, so it is an express agreement. So here the agency has come into picture by an express agreement. See, this is an express appointment. This is the example which explains the first mode of agency. And if you see the second example, if a customer of your bank wishes to transact his banking business through an agent, The bank will require a written evidence of the appointment of the agent and will normally ask to see the registered power of attorney appointing the agent. So normally, if something is to be done through an agent with respect to some banking transactions, a bank should be given some evidence stating that some power of attorney to appoint him as an agent, and his powers should also be enshrined in that. Thereby, the person can continue as an agent, and the agency will come into the picture. That is the second example. Right. So the first mode is the by express authority, and the second one is by implied authority. By implied authority, how a agency will be created. An authority is said to be implied when it is to be inferred from the circumstances of the case. When the authority is said to be implied when it is to be inferred from the circumstances of the case, and things spoken or written or in the ordinary course of dealing may be accounted from the circumstances of the case, and this you will understand with this simple example. Right. If a person realizes rent and gives it to the landlord, he impliedly acts for the landlord as an agent. So there is if a person collects the rent and gives to the landlord, what is happening here? Here that person who is collecting the rent and giving it to the landlord is acting as an agent. It is an implied act. It is implied an act which is giving rise to establish an agency, and which is giving rise to have a relationship of agent and principal, right? So this is implied authority where a agency can get established. And third one is agency by estoppel. An agency by estoppel is based on the principle of estoppel. The principle of estoppel lays down that when one person by declaration, act, or omission has intentionally caused or permitted another person to believe a thing to be true and to act upon such belief, he shall not be believed to deny his previous statement, or he shall be stopped to deny his previous statement or conduct. So, this agency is implicit under Section 237 of the Contract Act. So, when an agent has without authority done acts or incurred obligations to third person on behalf of his principal, the principal is bound by such acts or obligations if he has by his words or conduct induced such third persons to believe that such acts and obligations were within the scope of agent's authority. So the actions or the words of the principal, if it gives a kind of a faith to the third person that so and so is the agent of principal to do certain actions, then automatically whatever the actions that the agent will do with the third parties, which was spoken and which was caused the third party to believe that the agent is having the authority to act on behalf of the principal, these are all such cases which comes an agency by the principle of estoppel, right? So according to section 237 of the Contract Act, an agency by estoppel may be created when following essentials are fulfilled. So these are the essentials which have to be fulfilled to create an agency by the principle of estoppel. The first essential is that the principal must have made a representation. That is the first thing. So based on the representation of the principal only, the third party will believe that the agent is having authority to do something on behalf of the principal. The representation may be express or implied also. The representation must state that the agent has the representation what it has to state that the agent has an authority to do certain acts although really he has no authority. So the representation of the principal created an image in the mind of the third party that the agent has an authority to do certain act although really the agent has no authority, right? So this is an estoppel principle. The principle must have induced. The principle must have induced the third person by such representation. The third person, the third person must have believed the representation and made the contract on behalf of such registration, such representation. The third person must have believed the representation, and based on that belief he made a contract on the behalf of such representation. So if these essentials are satisfied, if these five essentials are satisfied, then an agency by estoppel principle will get established. You see an example so that you can understand that the agency by estoppel. A consigns goods to B for sale and gives him instructions not to sell below a fixed price. C, being ignorant of B's instructions, enters into a contract with B to buy the goods at a price lower than the reserved price. A is bound by the contract. A cannot plead that he had given to B instructions not to sell the goods below the certain price. An agency by estoppel is consequently deemed between A and B. Right. So this is one example. The next one is agency by necessity. An agency of a necessity arises due to some emergent circumstances. So, due to certain emergency circumstances, sometimes an agency arises. In emergency, a person is authorized to do what he cannot do in ordinary circumstances. Right? Thus, where an agent is authorized to do certain act, and while doing such an act, an emergency arises, he acquires an extraordinary or special authority to prevent his principal from loss. So that emergency should be to prevent the principal from a loss. So if you see this example, you will understand. Raja has a large farm on which Sham is a caretaker. So Sham is a caretaker means he is having the role of an agent. When Raja is in Canada, so when the principal was in Canada, there is a huge fire on farm. There was a huge fire on farm, which is an extraordinary circumstances, right? This is an extraordinary circumstances. Here there is a caretaker, here there is a owner, and there is a fire which is an extraordinary thing that was happened in that. Sham becomes an agent. So here by extraordinary circumstances Sham becomes an agent because of necessity. Because of the necessity he becomes an agent. Why he becomes an agent? To prevent his principal from loss. You understand the point, student? So here Sham becomes an agent of Mr. Raja. The reason is that to prevent Mr. Raja from a loss which is an extraordinary thing, which is an extraordinary circumstances, right? So the necessity of Raja so as to save the property being destroyed by fire, the Raja incurred to put out the Raja will be liable for any expenses Sham incurred to put the fire and save the farm from destruction during Raja's absence from the country. Right. So whatever this Sham has spent to protect the destruction of the property of Mr. Raja, and all such expenses should be get reimbursed from Mr. Raja, because there is a relationship of a principal and a agent which arises because of an emergent circumstances. In order to prevent the loss to the principal, here this agency has come into picture by necessity. The next one is a ratification. This is the fifth one, and which is a very important. So ratification means rights of a person as to acts done for him without his authority, effect of ratification. Here, which mean to say that the students, please understand, agency arises by ratification means certain acts were already done. Later on, principal ratifies the actions. So as and when he ratifies, he gives his post fact approval to the actions done, then automatically all such actions which was done without a relationship of principal agent will get the status of a agency as and when those actions are ratified at a later date by the principal. Let us see. Where acts are done by one person on behalf of another, but without his knowledge or authority, he may elect to ratify or to disown such acts. If he ratifies them, the same effects will follow as if they had been performed by his authority. In simple words, ratification means approving the previous acts. Ratification means approving the previous act or any transaction. Right, if you see this example, you will understand very easily. X, who is a vice agent, X is an agent, Y is a principal, has on 10th January 2019 purchased a goods from Z. Z is a third party on credit without Y's permission. So without Y's permission, agent has purchased some goods from a third party who is Z after the purchase on 20th January 2019. So which mean to say after 10 days of happening of this transaction. The original transaction was happened on 10th January, and it was told to the principal on 20th January. Y tells X that he will accept responsibility to pay for the purchases, although at the time of purchase the agent had no authority to buy on credit. So, Y's subsequent statement on 20th January 2019 amounts to a ratification of agent's purchase of goods on 10th January 2019. So thereby what happened? The agency arisen because of the ratification. So it is an agency by ratification. It is called an agency by ratification. So here there are certain essentials of a valid ratification. Dear students, here there are about five essentials of a valid ratification, not five. There are about seven essentials of a valid ratification. So, which mean to say you may get a full-fledged question about the ratification agency by ratification and what are the essentials of a valid ratification. What are the essentials of a valid ratification? So in such a case, you need to write about how a agency by ratification will come into picture, and what is you can give an example for that, and as well as you need to write all these seven essentials of a valid ratification. So this is a possible question for a marks of 5 to 6, and where you can get full marks if you could able to write all the seven essentials and the concept of arising agency by ratification. So the first essential is that ratification may be express or implied. Ratification may be expressed or may be implied in the conduct of a person on whose behalf the acts are done. So this is the first essential, wherein the principal can give his ratification either by express or by implied in the conduct of person on whose behalf the acts have done. Right. And the second essential is that knowledge requisite for valid ratification. No valid ratification can be made by a person whose knowledge of the facts of the case is materially defective. So, which mean to say that to ratify any actions which have been done already, the principal should have a knowledge of the facts of the case, right? If it is not, then it is materially defective, right? Let us see an example where you will have a better understanding. A has an authority from P. A has an authority from P to buy certain goods at the market rate. He buys at a higher rate, but P accepts the purchase afterwards. P comes to know that the goods purchased by A for P belonged to A himself. The ratification is not binding on P. The ratification is not binding on P. So here agent is A, principal is P, and agent purchased certain goods at a higher price, but unfortunately the principal has no knowledge of the facts of the case. The facts of the case he doesn't have knowledge, and his knowledge is materially defective, so that the ratification is not binding on principal, right? The ratification is not binding on principal. So the essential thing is that the principal should have the knowledge of the facts of the case which is materially defective. And the third essential of the ratification is effect of ratifying unauthorized acts forming part of transaction. Effect of ratifying unauthorized act forming part of a transaction. So in a transaction, the agent is having authority to if for some extent, and the other extent if he doesn't have authority, and both has done together as a one transaction. So by giving effect of ratification to the other unauthorized act, then automatically by ratification agency will come into picture. So a person ratifying any unauthorized act done on his behalf ratifies the whole of the transaction of which such act formed a part. There can be a ratification on F. There can be ratification of an act in entirely, or its rejection in entirely. The principal cannot ratify a part of the transaction which is beneficial to him and reject the rest, right? If a part of a transaction the agent is having authority and the other part is not having authority, however the transaction is completed, in all such cases the principal he can either ratify the transaction or he can reject the transaction, but he cannot make ratification to a certain part of a particular transaction, right? The principal cannot ratify a part of the transaction which is beneficial to him, and he cannot reject the rest. He can take either as a full only. So in such a case, that is very much essential for a valid ratification agency. And the fourth essential valid point for a ratification agency is that ratification of unauthorized act cannot injure third person. So very simple. Any ratification should not injure the third person. An act done by one person on behalf of another without such other person's authority, which he done with the authority, would have the effect of subjecting the third person to damages. So, if the effect is affecting the effect is that subjecting a third person to damages or of terminating any right or interest of a third person cannot by ratification be made to have such effect, right? So in another words you can say, when the interest of third parties is affected, the principle of ratification does not apply. Whenever the third party's interests are affected, in all such cases, the principle of ratification to have agency will not apply. And the fifth essential point of a ratification is ratification must be made within a reasonable period of time. And the next one is a communication of ratification. Ratification of transaction at a later date by the principal must be communicated to the other party, and the act to be ratified must be valid. It should be valid. Act to be ratified should not be a void or illegal. For example, a payment of dividend out of capital is void and cannot be ratified. So the payment of dividend is allowed out of the profits available for distribution as a dividend to the shareholders of the company. So that action can be ratified, but it is not the payment of dividend out of the capital. Capital out of capital, the dividend is void and it is illegal, hence it cannot be ratified. So the essential point here is that act to be ratified must be a valid one, must be a valid one. So the next important possible question or the out of the course content is write about the agent's authority. Write about the agent's authority to bind principal to third parties for the actions of the agent. Right. So, what is the authority of an agent to bind the principal to the third parties? See, the agent is a link between the principal and the third party. So, what is the authority agent is having is to bind the principal for his actions to the third parties. And what is his authority? To what extent he can exercise his authority with regard to binding the agent for the actions done. So, what the law says with regard to that, we will study right now. The authority of an agent means his capacity. The authority of an agent means his capacity to bind the principal to third parties. The agent can bind the principal only if the acts within the scope of authority. Right? Only if the acts within the scope of authority. So, principal will give some authority to the agent to do certain actions or certain transactions. So, as long as the agent do within the given authority, so long the principal is binded to all the third parties for the actions done by the agent. The extent of an agent's authority, whether expressed or implied, is determined by the following. One is the nature of the act or the business he is appointed to do. Second one is things which are incidental to the business or usually done in the course of such business. Third one is the usage of trade and or business. Whatever be the nature or the extent of agent's authority, it will always include the authority to do. See here, every lawful things necessary for the purpose of carrying it out will bind the principal and it will come into the extent of authority of the agent. Every lawful things justified by various customs of trade will also bind the principal, And the in an emergency, all such acts for the purpose of protecting the principal from the loss, as will be done by a person of ordinary prudence in his own case under similar circumstances, should also bind the principal to the third parties. The agent's authority is governed by two principles, namely, in normal circumstances and in emergency. So, in normal circumstances, there are certain things which will bind the principal to the third parties, and in emergency also. Let us see agent's authority in normal circumstances. An agent having an authority to do an act has authority to do every lawful thing which is necessary in a order to do such act. An agent having an authority to carry on business has authority to do every lawful thing necessary for the purpose. Every lawful thing. You have to remember, every lawful thing necessary for the purpose are usually do in the course for conducting of such business. You see the example so that you will understand this agent's authority in normal course in common terms. A is employed by B. So A is employed by B. So which mean to say B is a agent, B is a principal, and A is agent. And Mr. B is residing in London. The principal is residing in London. The duty of Mr. A is to recover at Mumbai a debt due to B. So some amount is due to Mr. B, who is residing in London, and A is being employed to collect that debt amount. A may adopt any legal process. A may adopt any legal process necessary for the purpose of recovering the debt, and may give a valid discharge for the same. So, in the normal course, to collect the debt, what is to be done? You have to ask for money. If the money is not given, you have to resort to a legal process necessary for the purpose. So, that is the ordinary course. That is the normal circumstances. So, in that all normal circumstances, whatever the actions that have been done by the agent is within his authority, all such actions will bind the principal, right? And agent's authority in an emergency. An agent has the authority in an emergency to do all such acts for the purpose of protecting his principal from loss. Emergency means protecting his principal from loss, as would be done by a person of ordinary prudence in his own case under similar circumstances. So, if it is of the a ordinary person's property, whatever the efforts he will put up to protect the damage to his property, the all such efforts should be kept, should be put in place with respect to the principal's property. To constitute a valid agency in an emergency, to constitute a valid agency in emergency, the following conditions must be satisfied. There are about five conditions which are given to establish that there is an emergency. The first condition says that agent should not be a in a position or have an opportunity to communicate with his principal within the time available. So agent doesn't have a time to communicate to the principal and take his consent for the actions of the agent. And the second condition is that the second condition is that there should have been actual and a definite commercial necessity for the agent to act promptly. So commercially, there is a necessity for the agent to act promptly. And the third point is that the agent should have acted bona fide. Bona fide means with good faith and for the benefit of the principal, not for his selfish interest. It is for the benefit of the principal with a genuine and with a good faith. If an agent acts, or that has to be there to make it the agency in an emergency as a valid one. And the next one is the agent should have adopted the most reasonable and practical course under the circumstances. So here, what all the actions of the agent should be reasonable and practicable course under the circumstances. And finally, the agent must have been in possession of the goods belonging to his principal and which are the subject of a contract, right? So if you see an example, an agent for sale may have goods repaired if it be necessary. An agent for sale may have goods repaired if it is necessary. So that is one thing where the emergency situations will create agency between the persons as a principal and agent. So the next topic is about subagents. So this is a one good important thing and one good important topic as well. You will be asked to write about the legal provisions with reference to appointment of a subagent and the exceptions to appoint a subagent by the agent under contract of agency. So here you know that so far that an agent will be appointed by a principal. Here the subagents or been sometimes will be appointed by agent. So that will not be acceptable in the law. However, there are certain exceptions. Now we will study the subagent's appointment and what are its exceptions. When agent see, agent cannot delegate. When agent cannot delegate his duties and the rights, the agent cannot lawfully employ another to perform acts which has been expressly or impliedly undertaken to perform personally, unless by the ordinary custom of trade a subagent may, or from the nature of the agency, a subagent must be employed. So here what it says is that under section 190, in normal course, an agent cannot lawfully employ another person to act on his behalf as a subagent. However, in the ordinary custom of trade, a subagent, if normally been appointed, then it can be allowed. That is what it says. Subagent is a person employed by and acting under the control of the original agent in the business of agency. This is the definition of a subagent as per section 121. A subagent will be appointed by the agent and the agent is the original agent in the business of agency. And there are certain exceptions where an agent can appoint subagent. So the one exception is that the appointment of subagent would be valid if the terms of appointment originally contemplated it. So if the terms of appointment, if it was originally contemplated, uh, in such a case, a subagent can be appointed by the agent. And sometimes the customs of trade may provide for appointment of subagent. In both cases, subagent would be treated as an agent of the principal. So, if the customs of the trade or if originally contemplated to appoint a subagent in the first case and the second case, in both the cases, the subagent is also will be treated as an agent and all the actions of subagent will bind the principal to the third parties. And the third exception to appoint a subagent is wherein the course of agent's employment unforeseen emergency arises which make it necessary for him to delegate authority. So because of unforeseen circumstances, if the agent is required to delegate his authorities to carry out certain actions, in all such cases it could be considered as an exception and a subagent can be appointed. A representation of a principal by subagent properly appointed. By subagent properly appointed, where subagent is properly appointed, the first thing is that the principal is so far as regards third persons represented by the subagent and is bound by and responsible for his acts as if he were an agent originally appointed by the principal. And the agent's responsibility for subagents. The agent is responsible to the principal for the acts of the subagent. So agent is responsible to the principal, not to the subagent. And subagents liable to principal. The subagents is responsible for his acts to the agent only, but not to the principal, except in case of a fraud or willful wrong. Except in case of a fraud or willful wrong. And agent's responsibility for a subagent appointed without authority. Where an agent without having authority to do so has appointed a person to act as a subagent, in such a case the responsibility of the agent is that the agent stands towards such person in relation of a principal to an agent and is responsible for his acts both to the principal and to the third persons, right? Here agent will be like a principal to the subagent and he is responsible to the third persons. And the principal is not represented by or responsible for the acts of the subagent. The subagent is not responsible to the principal at all. He is answerable only to the agent. So here a subagent is not responsible to the principal and he is answerable only to the agent. A principal is not represented by or responsible for the acts of subagent. The subagent is not responsible. The subagent is not responsible to the principal at all, and the subagent is answerable to the agent only. So these are the certain points under this particular topic regarding the subagent and his legal provisions, his appointment of subagent and the exceptions to appoint a subagent under the contract of agency, and as well as the responsibilities of principal, agent and subagent as and when some subagents are appointed by the agent due to certain exceptional circumstances have been discussed. And before going to the next topic, now we will take a break for this session. I thank you all with best wishes.